Decision podcasts by the New York Prosecutors Training Institute are made possible by VoicePods. Convert your text to voice at voicepods.com. Read this decision at NYPT Law. www.nypti.org/law.
People v. Garland. Decided November 20, 2018. The order of the Appellate Division should be affirmed. Defendant challenges his first-degree assault convictions, arguing that the evidence against him was not legally sufficient to establish the element of serious physical injury. Penal Law Section 120.10(1)(3). Serious physical injury means physical injury which creates a substantial risk of death, or which causes death or serious and protracted disfigurement, protracted impairment of health or protracted loss or impairment of the function of any bodily organ. Penal Law Section 10.00(10). In reviewing a legal sufficiency claim, the court must view the facts in a light most favorable to the people to determine whether, as a matter of law, a jury could logically conclude that the people sustained its burden of proof. People v. Danielson. This deferential standard is satisfied so long as there is a valid line of reasoning and permissible inferences from which a rational jury could have found the elements of the crime proved beyond a reasonable doubt. People v. Acosta. In this case, defendant fired 5 shots into a crowd and struck a 15-year-old bystander in the leg. According to medical records, the bullet was lodged in the soft tissues of the victim's leg. An X-ray showed 2 fragments of the bullet on the side towards the front of the thigh, and the possibility of multiple other, smaller fragments. The victim testified at trial that, after the shooting, the injury hurt and he was bleeding a lot. He had crutches for about 2 months and, after that, there was a lot of limping, crutches in the shower. The victim indicated that the ordeal was very traumatizing. The bullet fragments were never removed from the victim's leg. Medical records indicated that the injury was close to the victim's femoral artery, a big blood vessel, and, as a medical expert testified at trial, where a bullet enters an extremity, we don't take the bullet out in the trauma situations because going after a bullet like this can cause further injury. In particular, where a bullet is lodged near a blood vessel, actually taking it out can cause injury to that blood vessel and near around it, resulting in bleeding, neurological deficit, numbness, tingling, and weakness. The expert further noted that, had the femoral artery had been struck with a bullet, possible medical complications could include exsanguinating, bleeding, excessive bleeding, and possibly loss of limb. The victim testified that he can still feel the bullet poking out, and that he continues to endure the effects of the metal inside his leg, even 4 years after the shooting. The victim noted that the injury still disturbs him at times, and that something is wrong with his leg. The victim stated that, because the bullet didn't come out of his leg, his life had been tampered with. For instance, he can no longer participate in competitive sports, as the injury would present a very big risk. The medical expert further testified that there are many repercussions of the type of muscle damage that the victim sustained. Muscle damage can cause long-term injuries to the kidneys from leakage of chemicals from the muscle, toxic to the kidneys, can cause pain and weakness, difficulty walking. As the dissent notes, there is certainly record evidence favorable to the defense that, when viewed in isolation, might have presented an issue of fact for the jury. That said, viewing the evidence in the light most favorable to the people, as our legal sufficiency standard requires, we have no trouble concluding that the jury acted rationally in finding that the victim's gunshot wound constituted a serious physical injury. Penal Law Section 10.00(10). We have considered defendants' remaining contentions and conclude that they are without merit. On review of submissions pursuant to Section 500.11 of the Rules. Order affirmed. In a memorandum, Chief Judge DeFiore and Judges Stein, Fahy, Garcia and Feynman concur. Judge Wilson dissents in an opinion in which Judge Rivera concurs.
Decision podcasts by the New York Prosecutors Training Institute are made possible by VoicePods. Convert your text to voice at voicepods.com. Read this decision at NYPT Law. www.nypti.org/law.